So I request you, sir, please you start your lecture. Now floor is yours. And, please you start.
Good morning to all of you. I am thankful to the this Madan Mohan Malviya Center for Teacher Learning, AMU Aligarh, and especially to the director and
Ah,
the Madam Professor Nasreen for giving me this golden
thank you.
opportunity. It is always a feast, rather it is always an honor whenever we get an opportunity to talk to the young colleagues of ours, and that too from the floor of AMU Aligarh, where I have been for about 15 years pursuing my education way back 40, 50 years back. Anyhow, as desired by the Madam Professor Nasreen Mujib, that I am supposed to interact with you on law, legal awareness, and supremacy of the Constitution. Whatever your subject may be, or whatever your profession may be, whatever your occupation may be, I think every one of us is supposed to know about the basics of law. There is a maxim, latent maxim in law, that ignorance of law is no excuse. Ignorance of fact may be an excuse, what we technically call mistake of fact may be excused, but mistake of law is never excused. That nobody can plead in the court of law that I was not knowing that this is the law. This is no excuse. But if you can succeed in the court of law to establish that the facts, circumstances of the case which makes your act or your commission or omission of an act punishable, if you can prove that I was not aware about these facts, maybe you can be excused. That is what I mean. Everyone, every citizen, every individual has to know about the facts of each and every case. Now, this is a very, very wide spectrum, and perhaps I may not be in a position to do justice with the topic within this short span of time, 90 minutes, and it will not be of any use to you unless you ask me questions once I kick the ball. Well, I give leverage and liberty to all of you, to my worthy younger colleagues, that you can intercept anytime you like. You can raise a hand and unmute with the permission of the director, with the permission of the program coordinator. You are at liberty to ask the question you feel is appropriate as your perception. Now, coming to the topic, am I audible and visible? Because I am out of my office.
Yes,
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 Is
sir.
it okay?
Yes, sir. Yes, sir.
Is it okay? Yes. Well, you see, the basic three terms which emerge once we talk about law is law, society, and justice. Law, society, and justice. And when we talk of law in brief, it is said it is command of the sovereign. Well, who is sovereign? What is meant by sovereign? That I will discuss with you in the due course of time. And what is society? You know, society means a group of the people who are living together in a system, what we call now legally as a state. Organized society we call as a state, and they are governed by those laws, the command of the sovereign. And then what is justice? Justice means you must, as a citizen, as an individual, get what is due to you without encroaching, without impacting the rights of others. This is called justice. If I am aggrieved, I have a right to approach to the authority. I have a right to approach to the court to seek redressal. And if my grievance is addressed not as per my perception, but as per law of the land, it is said justice is delivered. Well, my dear colleagues, this law, society, and justice, they are relative terms, and the concept varies from society to society, from community to community, from time to time, depending upon various available factors. As I said, law is command of the sovereign. It is a definition given by one of the known jurists known as Austin. Now, what is meant by who is sovereign? Can any of you tell me who is sovereign so far as Indian democratic setup is concerned? We will discuss this law and society and justice in our own perspective, not in the global perspective, in the Indian perspective. Can you tell me who is sovereign so far as India is concerned?
People are sovereign.
People of India.
People of India are sovereign.
People of India are sovereign.
Sir,
But
independent
practically
in
speaking, you are right. Their
independent in
sovereign,
internal external affairs.
their sovereignty is visible and actionable only once in 5 years. So far as the vote is in my hand, I am sovereign. Once I cast my vote, my sovereignty comes to close for next 5 years. I don't know. This is a practical aspect. Well, theoretically, you are right. People are the supreme in a democratic setup. People can make or unmake the government. The people can change the governments. If people can form the governments, but this sovereignty practically lies somewhere else. At least for after casting our vote, we have surrendered this right to our representative. He may be in your legislature, in whose favor you casted your vote, or he may be in your parliament, whatever the case may be, or he may be in your local body, a panchayat. You have given your right to take a decision, to make a law to your representative. Thereby, practically speaking, theoretically, it may not be true. Practically speaking, you have subjugated. You have given your right to make the law, your right to form the government, your right to change the government to the your person to whom you have elected to the local body, the person to whom you have elected to the legislature, the person to whom you have elected to the parliament. What is going on in the scenario, I need not to discuss you. All of you are learned people. You can go to these various agencies who come with the figures, who are in our local bodies, what are their antecedents, who are in our legislatures, what are their antecedents, who are in our parliament, what are their antecedents and their records. The figures are available. You can go to any website and you will find what is the actual position. Anyhow, after having said it, now I do agree with you. People are the supreme. People are the sovereign. They have a right to form the government. They have a right to change the government. They have a right to give a call that what should be or what should not be the law. How to deal or how not to deal with a particular situation. Here, one more point comes to my mind because this lecture is not organized. I have a PowerPoint presentation which I can't display over here. Now, another point which emerged over here, what is the difference between morality and legality? Or you may say immorality and criminality. Or before you come to immorality and criminality, is there any difference between sin and immorality? Sin and immorality. Any difference it appears to you?
Well, I think sin is related to something which religion ordains. It pertains to the religion sanction. Sin is defined by religion.
And
And immoral
morality?
is immoral is defined by society. Yeah.
And criminality?
Sorry, sir. Cruelty?
Yeah.
Well, cruelty is also
Criminality, not cruelty. Criminality. Crime.
criminality is also defined by the law. It's the law of the land.
You are right. But I will put it like this. Sin is what is ordinated to you by your conscience, by your family, by your neighborhood. And as you rightly said, that all revolves around your faith. Well, Azan is going on. I don't bother to go to offer a namaz. Well, my elders will say, a sin, you have committed a sin. Well, you are supposed to go at a particular time to the Gurdwara or to the temple or to the church. You don't go. Well, your elders, your ancestors will try to guide you that it is a sin not to pray at a particular given time. Similarly, if in our joint families, जब खाना परोसा जाता था, अगर आप जूठा कुछ छोड़ते थे तो आपकी दादी, आपका दादू या आपके जो भी एल्डर्स थे वो आपसे कहेंगे भाई प्लेट खाली, प्लेट साफ कर लो वरना ये गुनाह है, खाना जूठा छोड़ना गुनाह है ना. This is, as you rightly said, it is a personal perception. But this sin which is labeled by your own conscience, by your faith, whatever the case may be, can take the shape of immorality if it gets the label of what we call society as a whole. You rightly said it. Yani when society says कि ये जो act है ठीक नहीं है, ये जो आपका conduct है ठीक नहीं है, ये आपका जो behavior है ठीक नहीं है, we may say it is immoral. जैसे many issues are emerging. अभी आपके अलीगढ़ के इर्द गिर्द में 2-3 केसेस हुए, वो भी मैं डिस्कस कर लूंगा. And then criminality, the larger society, what we call state, organized society, what is labeled by the society is illegal, is crime, that is called as a crime. What is labeled by the self, by the family, by the faith, we call it as a sin. And then the sin, these are three circles encroaching, overlapping with each other. In between is immorality. What is going on? What is as per the perception of the society, community, we call it as an immoral. Then what is as per perception of the state? What is not?
Sir,
yes.
hello, sir. I want to say that here morality comes from our individual consciousness. It is very necessary that we call that is vivek in Hindi or that is vivek from our own consciousness is very necessary in this connection. I think so.
Yes,
I think
collective consciousness. That is where it is a group of the people of your like-minded people. Now here I will try to give some examples. Now you take the example of abortion. Take the example of living in relationship. Now take many examples. Here, what is my point at the end where I want to take you? What may be a sin may not be immoral. What may be immoral may not be a crime. What may be a crime may not be immoral. Many examples I will give where it is a crime, but it may not be immoral. It may be accepted by your conscience. It may be accepted by your group mores, by your family, but it is a crime. Take the example of abortion. Is it a sin? Is it immoral? What is it?
ये तो सर पर्सपेक्टिव से पता चलता है ना कि abortion
unwanted abortion, is it immoral, is it a sin, or is it a crime?
It is crime in India, but it is not a crime in West.
Yes. What is Madam rightly said, ये पता चलेगा in the circumstance. Where the abortion is not as permissible under the Termination of Pregnancy Act, we can say it is sin, it is it is immoral, it is a crime. Okay. Similarly, take the example of live-in relationship. What is this? Is it immoral? Is it sin, or is it crime? Live in relationship.
Well,
Yes,
it differs from society to society, sir.
yes.
Sir,
I'm sorry. Will be check? Okay. Well, sorry. Is it a sin? Is it a immoral, or is it a crime? Say, live in relationship.
so it differs from society to society. I mean, in, in Western society is considered perfectly normal, but in Indian context,
Let us
yeah,
talk of our own India. Let us
well,
talk, because our India is a very vast.
yeah, it is immoral. It is immoral in India. Largely, it is considered immoral. In some of the societies, in some groups, it might be considered all right, but largely it is considered immoral.
Well,
But
my
it is
dear
lawful,
friend,
sir.
you are
But sir,
right.
legally,
But it is lawful.
from
It is lawful.
It is lawful. Well, you see here, this is the disadvantage of this online, because we can't talk face to face, one to one to each other. Well, you see, you are right so far as live in relationship for me, a person of my age. It is totally immoral. It is totally unethical. I can never accept it. By I mean people of my age, people in my age group. They will never accept it. Nobody in the joint family will accept live in relationship. As you might have read in the newspapers, at one point of time, I think 7, 8 years back, there was a tussle between Khap Panchayat and that of the Supreme Court. And Khap Panchayat said, whoever goes for live in relationship, we will kill both. And they did in
sir,
Khap Panchayat.
then intercaste marriage is also not moral. Intercaste marriage, interreligious marriage is
उस
not
पर भी
moral.
मैडम उस पर भी मैडम मैं आ जाऊंगा. यहाँ पर जो है इंटरकास्ट मैरिज ही था इशू, which was taken by the Khap Panchayat, where both were killed, and the Supreme Court issued the direction to the police to arrest all the members of the Khap Panchayat. Then that tussle took anyhow. Finally, Supreme Court didn't prevail. Now here you see this cycle. I will just cut it short here. We will move further. This cut short, you cannot come out of this tangle. Sin, immorality, and that of criminality. These are three circles overlapping with each other. But unfortunately, with the so-called development, with the so-called materialism, the concept of sin, the concept of immorality is taken over by the concept of legality. One of the participants rightly said, live-in relationship is legal. Yes, it is legal. The Supreme Court decisions, a number of Supreme Court decisions, where even the children of who are offshoot, who are the outcome of this living in relationship, are entitled to the property rights, like that of other children of the marriages which are solemnized as per the faith, as per the law. They will also get the same treatment is to be given the children of the living relationship and that of the. And of late, everyone of my age was shocked when the Supreme Court gave a judgment regarding adultery. Regarding adultery, that adultery was also decriminalized in Joseph's case, one of the famous case, where the Supreme Court said that it violates Article 14. Article 14 of the Indian Constitution, which gives which guarantees equality before law and equal protection of laws. Try to apply your mind as a teacher. Try to apply your mind as a member of a family. Try to apply your mind as a normal human being. Once in a family in the Indian setup, we say adultery is not punishable. Adultery is not a crime. Is it moral? Does it make it moral? Does it make it, it is not sinful? I think not at all. To us, to the Indian families, adultery will continue to be immoral. Adultery will continue to be sinful. Well, the Supreme Court has said, and now, now, now the new law which has come in place of the Indian Penal Code. Now we have Bharti and as Sanita. Adultery has Yes, sir. Any question, Mohammed Anas Saab? Either you mute your speakers or you ask the question. Well, this is not now an offense. Now here rightly we come to the conclusion without going further discussion on the issue. Even the same-sex relationship, even the same-sex marriage, many issues are now emerging in this 21st century, which perhaps our criminology, our penology, our legality, these were unknown 50 years back, 40 years back. Anyhow, the concept of morality, immorality, legality, illegality, it depends upon community to community, society to society, country to the country. What may be regarded as a crime in one country may not be regarded as a crime in another country. What may be regarded as a crime in one society may not be regarded the same in the another society. What may be a crime today may not be a crime tomorrow. What was not a crime yesterday may be a crime today. It will depend. Take the example of bigamy. Bigamy basically is not an offense. But now, yes, but now by virtue of the law of the land, it is an offense. It carries punishment. Even in some societies, polyandry is not an offense. I'm not talking of India. Even in India, it is in practice in many parts of the country, some part, especially in Ladakh. Well, after having said it, now I think I must move. If you have any question regarding morality, immorality, and criminality, I think I must move ahead so far as my basic topic, the laws and constitutional supremacy is concerned. I will take a big jump. I don't know what is the time. Yes, it is 9:26. Hardly 1 hour is left. If you have any question regarding this, because we could not conclude it. We could not conclude it. Well, my dear friends, you see, when we talk of law, nobody is aware about what are the laws which are available. कुछ laws हमें पता है, कुछ laws हमें पता नहीं है. इसीलिए अगर आप देखते हैं सुप्रीम कोर्ट में भी जब कोई जाता है वो किताब लेके साथ जाता है, हाई कोर्ट भी जाता है किताब लेके भी साथ जाता है. यानी the laws are being made, laws are being changed, laws are being modified, and coming basic to the point, now the laws are made by our legislature, by our parliament, and we can say these are made by the people of India, because as I said in the beginning, we have our representatives over there. And whenever a law is made by any state legislature, by any local body, or by the parliament, the strong presumption is that this is as per Constitution of the India. This is as per the provisions of the Constitution. Then there are other laws as well. You see, the apex law in our India, the basic Bible, which is called the Constitution of India. That is on the apex. Then there are many thousands and thousands of laws, thousands and thousands of codes, acts, which I will try to spell out. Now, if you remember, so far as the Constitution of India is concerned, it is a supreme law. Well, of course, it should not violate the supreme law. The constitutional law should not be in violation of the law of nature, natural law. If you have any idea, here just 2 minutes, 5 minutes I will take. If you have any idea about the Constitution, it is said the Indian Constitution is one of the best constitutions in the world. And it came into being on 26th of January 1950. And you might have also heard or read, must be aware, how many of you are from law? Political science, sociology. Anyone from law? Anyone from political science?
Yes, sir.
Yes, sir.
Dr. Ambedkar is the godfather of this very constitution. And if you go through the history of it is the basis of this constitution is 1935 Act. And thereafter, Dr. Ambedkar, along with his drafting members of the drafting committee, they visited various countries, borrowed something from UK, borrowed something from USA, borrowed something from Ireland, borrowed something from Japan, borrowed something from Switzerland, many countries. But they took the best part from those constitutions and brought it into what we call Indian Constitution. That is why even other Supreme Courts of the world of various countries, they say Indian Constitution is the lengthiest constitution, written constitution, and the best constitution of the world. Now, what this constitution provides? This constitution provides you right from panchayat, powers of the members of the panchayat, up to the powers of the honorable president. And all
Bhalu sir, please mute it.
am I audible?
Yes, sir, you are audible.
Yes, sir.
All other bodies, you may talk of parliament, you may talk of state legislature, you may talk of powers of the president, you may talk of powers of the honorable prime minister, you may talk of the powers of the council of ministers, you may talk of the powers of the governor, you may talk of the powers of election commissioner, you may talk of the powers of the Supreme Court, you may talk of powers of the other autonomous bodies, even Union Public Service Commission, all bodies. It will be difficult to name all of them. They derive their composition first. Composition is important. Their constitution, rather, how it can be formed, how the Council of Ministers, how the Parliament can be constituted, how the Rajya Sabha, Lok Sabha, how the President can be appointed, Vice President can be appointed, Speaker can be appointed, Prime Minister can be appointed. All this is provided under what we call the Indian Constitution. Everything is covered. Powers of the Supreme Court, powers of the various other courts, high courts, and all, everything. You may talk of anybody. Then there is another chapter that is called as directive principles of the state, where directions are given not only to the state but also to the citizens, that what they are expected to do in the given circumstance. What are their duties in the given circumstances? That of the state, that of the. If you have any question, you can ask, because I can't elaborate it. And that of this, what we call even citizen, all the citizens of India, they too are under certain directions, what to do, what not to do in the given circumstances. Nobody talks about the basic, which is the, you can say, main thing of the Indian Constitution. It provides you what we call fundamental rights. Fundamental rights under chapter 3, wherein certain guarantees, which if the time permits, I will try to elaborate. Certain guarantees are given to every citizen and even to every individual under certain circumstances. And these guarantees, if violated, these rights, if violated, fundamental rights, what we call, if violated, you have a right to get them enforced through what we call writ jurisdiction, both at the High Court level as well as at the Supreme Court level. Before I proceed further, We have a different types of the rights, because here fundamental rights came into question. You have a different types of the rights. One is legal right. First is human rights. Then you have a legal right. Then you have a constitutional right. Then you have a fundamental right. Any difference between these rights? Human rights, legal rights, constitutional rights, and fundamental rights. Any of you who can guide me, any difference, just broadly speaking, mote तौर पर. Well, human rights are the rights which are born with us, which are natural with us, and then subsequently guaranteed.
Sir, all these rights are constitutionally secured to some extent. Can't hear you, sir.
कनेक्शन कट गया लगता है. Please wait 1 or 2 minutes. I am making contact with him. हाँ कनेक्शन कट गया है सर शायद. Please wait. I am going to search what happened. Yes, ma'am.
Okay, ma'am.
Okay, ma'am. Okay. Okay, ma'am.
Okay, ma'am.
Am I audible?
Yes, 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 sir.
Yes, sir.
Yes, sir.
Yes, sir.
Broadly speaking, legal right, as I said, human rights are the rights which are born with us. They are natural, God given, and the legal rights are the rights which are given to you by statutes, various ordinances, various statutes, but they do not fall within the fundamental rights. And then the constitutional rights are the rights which are given to you by the Constitution, but cannot be enforced by writ jurisdiction. Example, you have a property right, which was earlier a fundamental right. Now it is a constitutional right, but it cannot be enforced. And then the fundamental rights which the state, unless the due process of law is followed, you cannot be deprived of it. And it is enforceable by writ jurisdiction, that is called as a fundamental right. And this is the series. Human rights is on the cap, on the top. Then you have the legal rights given to you by the statutes. I have a right that nobody will enter into my land. I have a right that if my neighbor constructs a house, he has to leave a fire gap. It is a legal right. Then you have a constitutional right, which have been guaranteed to you, which have been given to you by the Constitution, like right to property and many other rights, but that is not a fundamental right. But the fundamental right are those rights which are under Part 3 of the Constitution and are known as a fundamental right, as I say, right to liberty, right to life, right of equality. These are enforceable, and thereby they are called as a fundamental rights. And now, as I said, the Constitution is a supreme law. Then many laws are dealing with our day-to-day life, which are being enacted by the parliament, which are being enacted by the state legislature. State can also make a law. You take the property laws, you take the family laws, you take the contractual laws, you take the corporation laws, you take the company laws, you take any law, and you take the penal laws, you take the procedural laws. These laws have to be in tune with the provisions of the Constitution. if any law which is enacted by the state legislature or which is enacted by the parliament is not in tune with the provisions of the constitution, then such law can be challenged, and if found by the Supreme Court that it is in contravention to any of the provisions of the Constitution, it can be declared as null and void. Now here I will take you now one by one. If you have any question, please do. Do you follow this point? Crux. On the top is the Constitution. Every law, whatever the law may be, it may be personal law, it may be any other law, that has to be in tune with what we call the provisions of the Constitution. Here, off and on, you might have read in the newspapers, even at present, the controversy is going on, but I am not going to discuss those issues, but I will simply just tell you about a spark of it. The powers of the president, the powers of the parliament, and that of the powers of the Supreme Court. The case is pending in the Supreme Court. It may be regarding the appointment of the Chief Election Commission, members of the commission. It may be the example of the appointment of the director ED, Enforcement Director CBI, and that of the Supreme Court. Case is pending in the court and it is going on. Perhaps you got what I want to convey you. And of late, it may be the case of the Tamil Nadu cabinet and the Tamil Nadu governor. The case has been resolved by the Supreme Court, wherein the Supreme Court said that the Constitution, but the relevant provision does not empower the governor to withhold the bills passed by the state legislature for an indefinite period. He has to reserve, he is within his rights as per, to reject it, to return it, or to approve it. But the Supreme Court said he has no right to withhold them for a longer time. And then the Supreme Court also said in the same case, Tamil Nadu versus the governor of this Tamil Nadu, state government versus Tamil Nadu, famous case, अभी decide हुआ Supreme Court ने. उसमें बहुत से controversies, you might have read the headlines. Even our Honorable Vice President, he also came with certain remarks, to which exception has been taken by a number of jurists. And the Supreme Court also said, even the Honorable President of India has no right to hold the bills for a longer time. The Supreme Court said there is a time limit. Within this time limit, perhaps whatever the time may be, 3 months, they have to resolve, either reject or approve whatever they feel appropriate. The Supreme Court cannot give a direction, approve it. The Supreme Court cannot give a direction to reject it, but the Supreme Court said they have to decide the case, they have to resolve the case within the specified time limit. Now here, the question arises, which is emerging, you might have heard in the various debates, who is Supreme? You have main three limbs in our democratic setup. One is the parliament, and the offshoot of the parliament is the what we call Council of Ministers, headed by the Prime Minister, Honorable Prime Minister. The President, Vice President, they all fall within the executive. And the second is the Supreme Court. And on the top of it is what we call Constitution. Out of these three, and the media is an informally important pillar of the society. These are four important pillars of the society: the lawmaking agencies, parliament, legislature, whatever the case may be, even panchayat, and then the executive, then the Supreme Court, and on the top is the Constitution. Which of these is supreme? I am not saying sovereign. कौन सा लग रहा आप इसमें? Who has the edge? Do you feel this has any relevance what I am speaking to you?
Constitution.
Constitution of India.
Constitution of India.
Constitution of India. Well, here now I will give you some case law. वो case law which are landmark judgments, which perhaps every person might be aware because they form the headlines. Well, it will appear to you from these cases. I will take one by one and now some issues. From these cases, it will depend. The pendulum varies. Who is supreme? Who is supreme? The pendulum varies. कभी कभी आपको लगेगा it is parliament. कभी कभी आपको लगेगा it is constitution. कभी कभी आपको लगेगा it is Supreme Court. But you are right when you say it is the Constitution which is supreme. Theoretical. But practically speaking, as I said, you will see this pendulum is moving, pendulum is moving in different directions depending upon the situation. And what situation that I will try to explain. Go back. Manika Gandhi's case, Golaknath's case, these are famous cases so far as the supremacy of the Constitution or supremacy of the Parliament or supremacy of the Supreme Court issues were concerned. When in these cases, many other cases these are two main cases, wherein Gopalan's case, wherein it was laid down that the Parliament can amend the Constitution, but does not mean Parliament is supreme to the Constitution. The Parliament is at liberty to amend the Constitution, but it cannot touch the basic structure of the Constitution. What was meant by this? That the powers of the amending powers of the Parliament are making law powers of the Parliament are also provided within the provisions of the Constitution. That is, the Parliament is at liberty to pass any law they like. For that, they have their own mechanism. There must be majority to pass it. And then there is the assent by the Honorable President. That is a formality. This is law. But if anybody challenges this law and challenges on the ground that it violates X specific provision of the Constitution, well, the Supreme Court is supreme to interpret it. Try to follow the scheme. Constitution is theoretically supreme. The Parliament is supreme so far as lawmaking is concerned. The Supreme Court is supreme so far as interpretation is concerned. Do you follow my point? And this is not, I'm not talking of some technical legal language. I'm a layman's language I'm speaking to you. And thereby, if a law is passed by the Parliament, you challenge it, you approach the court, and you can approach the court only when you are in a position to specify that this violates this article of the Constitution. Only when you can make a case that it touches the basic fundamentals of the basic structure of the Constitution. And the Constitution has its own mechanism. The Supreme Court has its own mechanism as per the powers given by the Constitution. You see, the powers of the Parliament come from the Constitution. Powers of the Supreme Court come from the Constitution. Powers of any executive, right from Prime Minister up to the President, they come from the Constitution. Thereby, theoretically, you are right. I do agree with you. It is the Constitution which is supreme. But to me, from the case law, which I have read from time to time, this pendulum swings here and there. If your Parliament, if the party in power has an absolute majority in the Parliament, then perhaps that is supreme. Because they can make any law they like. And they can even supersede the decision of the Supreme Court. I will take you back 50 years back. You might have heard about a very famous case, Shah Banu's case. Any idea? Shah Banu's
Yes,
case
sir.
was the case pertaining to from MP. I am in
Talak.
Bhopal at the moment, pertaining to this state, where it was a question of that very old lady who was not given maintenance. And
Maintenance.
under the Sharia law, maintenance is to be provided only for poor period, that is for 3 months, whatever the case may be under the Islamic law. Now we say, whatever the law may be, super law is constitutional law. The case went to the Supreme Court. The Supreme Court interpreted that the lady is to be given maintenance till she is alive. Because where she will go, that very old lady, logical, as per the provisions of the Constitution. The Constitution has an edge over other laws, as I said in the very beginning. Then the Parliament passed the law. Parliament passed the law wherein they made a law, I think Muslim Marriage Resolution Act, something like that, 1939, wherein they said the maintenance can be only for the Tuhar period, and thereby gave a negative effect to what we call the decision given by the Supreme Court. Now, of late, take the example of Waqf Bill, Waqf Act, sorry, not bill. It has been passed by the Parliament. Now it has been dragged by to the Supreme Court, and certain provisions of the Act till the final decision have been kept on hold. Certain provisions of the Act under till the final decision is given by the Supreme Court. Supreme Court has reserved the decision. They have been kept on hold. They have been stayed. Similarly, take the example of AMU, minority status. Majority of you may be AMU. You might have heard about Aziz Basha's case, very old case, wherein the Supreme Court said that the AMU has been created by an act of a legislature way back in 1920, perhaps, by the British Act, and thereby it is not a minority institution. This was contested. Allahabad High Court upheld it. Supreme Court also upheld it. Then the Parliament came with an act, amendment to the AMU Act 1986, perhaps.
Sir, your voice is not clear. What disturbance are there? Your voice is not clear.
My voice is not clear.
Yes, sir. बहुत disturbed आ रही है.
I'm sorry, madam. I can't help it. This is the technology.
Yes, you please check your.
It is okay.
Madam is requested to check the set because voice is very clear on my set.
Okay.
Voice is clear.
Yes, madam is requested to check the set.
Okay. Okay. I was just my contention to explain to you that who is supreme. Now, in this AMU case, the case again went to the Supreme Court because this amendment of 1996 or something was challenged again in Allahabad High Court, and the Allahabad High Court said that this is unconstitutional amendment passed by the Parliament. Now the Supreme Court has reserved it is a decision. Last hearing was held somewhere by the end of 2024, December, something like that. Case is going on. This may be applying mechanism. Similarly, many cases are there where it will depend upon the situation. What is the strength of the Parliament? I mean, the strength of the Parliament, the party in power, and who are in the Supreme Court, to what extent the judiciary is being or has been controlled, and what is the status of the Honorable President? Is he or she above board, or he or she is also aligning to the mindset of the party in power, whatever the party may be. Thereby, to lay down a hard and fast rule, who is supreme, you can't say it. It will all depend upon the situation. But the foundation of the Constitution is that everyone has to work, whatever may be the status, right from Sarpanch to the Honorable President, right from member of Sarpanch to the Honorable Prime Minister, opposition leader, the Supreme Court, ED, CBI, other agencies, Union Public Service Commission, all other office of the governor, everyone has to work within the framework of the Constitution. And there is a strong presumption, and Justice Fazil Ali, in his capacity as the Chief, just said that in one of the cases, that you have to presume whenever any law is passed by the Parliament, we have to assume and presume that it follows so far as the Constitution is concerned, unless it is challenged. Now, let us take some of the laws which I would like to discuss with you, which pertain to day to day, unless you have some questions. Unless you have some questions, I gave you the controversy which is going on between even between the Tamil Nadu governor and that of the Supreme Court and the cabinet of the Tamil Nadu, and many cases. Even in Kerala, they made up a law where in the selection of the vice chancellor, the nominee of the chancellor has been dropped. Controversy has been raised, and the case has landed into the Supreme Court. Many cases. Now, of late, you need to be aware about some of the basic rights and some of the changes which have been brought into the 3 new penal laws: Indian Penal Code, Criminal Procedure Code, and the Indian Evidence Act. These are very important. Well, go to the crux, fundamental rights. Article 14. Article 14 of the Constitution provides what? Equality before law and equal protection of laws. Any idea about it? What does it mean?
Irrespective of caste,
All
creed, and
citizens
religion.
treated equal before law.
You see,
No any discrimination.
यहाँ पर मैं एक एज ए फ्रॉम कॉमन मैनर्स परसेप्शन आपको एक आपने शायद देखा होगा, कोर्ट में गए होंगे कभी, अगर गए नहीं भी कोई ना कोई पिक्चर देखी होगी. You always find that this lady statue, अभी उसमें चेंज आ गई. Lady statue is her eyes are blindfolded. Okay, and in one hand she has a tarazu. In the another hand she has a तलवार. कभी देखा है स्टैचू? हर एक कोर्ट के, हर एक जज के पीछे होता है.
Yes, sir.
Yes, sir.
इसमें अभी कंट्रोवर्सी आ गई. At the time of Justice Honorable Justice Chandrachud, former Chief Justice, he changed this statute in this statute in this Supreme Court. He replaces the he kept eyes open, removed this blindfoldedness, and then replaced the talwar by book, by the Constitution. A controversy emerged in the Supreme Court between the bar and the court. Anyhow, leaving that aside, what does it signify? Blindfolded lady having tarazu in hand and another talwar in the another hand. What does it imply?
Justice will be provided, no discrimination on the basis of religion, caste, creed, anything.
Yani Article 14 says it signifies what is provided basic fundamental right of equality before law and equal protection of laws. Again, theoretical. I would have enjoyed this lecture with you if it would have been in the offline mode. Well, again, theoretical. We say equality before law and equal protection of laws. Does it operate on the ground? Does it operate on the ground?
No, sir.
No, sir.
Well, it does not operate on the ground. I usually on these issues take a session with the district session judges and even high court judges. I raise 3 questions to them from the layman's angle. Can health services be purchased? Can degrees be purchased, educational degrees? Well, to these 2 questions, they say yes, because they are from judiciary, senior officers. Then the 3rd question I ask them, can justice be purchased? They say no. I contest with them, and in the latter vein, then they say we will file a case against you for contempt. I say, like that of healthcare, like that of degrees, justice can be also purchased. When I say healthcare can be purchased, you can have the best possible health service if your pocket permits. Well, when I say a gold statement, degrees can be also purchased. A number of fake universities or even some private universities, they provide you degrees after you just complete your formalities, depending upon, I did not to elaborate. Now, when I say justice can be purchased, well, those who are in the judiciary, or they say, sir, it cannot be. I argue with them the cases which they have decided. And I have developed a thesis, which is probably technical, but I will simply give 2 or 3 points. We say law is blind, meaning thereby equality before law and equal protection of law. But I tell them it is justice which is blind. And I write on the board the spelling of justice, J-U-S-T-C-E. I delete the word. What is the word remaining? Justice, J-U-S-T-C-E. What is the word missing?
I.
The word miss हो रहा है. Justice में. Dasa, good morning. Yes. Yes, sir. I had my breakfast. So everything is comfortable. So kind of.
No, pardon, sir. We could not hear.
No issues. I will come after 1 hour. Okay, I will come after 1 hour. Okay, sir. Thanks. Yes, sir. What is missing in? Am I audible?
Yes, yes.
Am I audible?
Yes,
Audible.
yes,
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 sir.
audible, very much audible.
What is missing when I say justice, J-U-S-T-C?
I.
I say them, I tell them that justice is also without I. Then they say how? I give them the judgments which they have given. You might have heard of a famous case, Delhi Tandoori murder case. You might have heard about that very Jessica Lal's case, where she was shot dead in Mehroli. You might have heard Priyadarshini Muthu murder case. And these are not known to only law students, but these are known to everyone, every common man. And I tell them, in these cases, the honorable court, the discussion judge, I quote what he said. He raised a finger towards the accused. In Jessica Lal's case, the accused was a well-influential person, a son of a very big gun in Haryana, Manu Sharma. The judge, while delivering the judgments, raised a finger towards the accused, saying that I know you have committed this murder, but I am sorry I can't convict you because I am short of evidence within court. I say this cements my argument, justice is without I. Then the second case, as I said, in Priyadarshini Muthu murder case, again, there the accused happened to be a son of the Commissioner Police, Additional Commissioner Police, Santosh Singh. She was raped. Both were studying in the same Delhi University. One, the Santosh was senior, and Priya was junior to him. Santosh moved a proposal for marriage, which Priya didn't accept. On this, some sort of differences took place between the two. Priya lodged a complaint at the police station. She was given a police protection. And since the Santosh was son of a big gun in police, the security cover which was provided to Priya was also under the influence of Santosh. One day, when nobody was in her room, he entered into her room, went on a motorcycle from the rear door, entered into her room. into her apartment and raped her and then smashed her head with his helmet. Evidence was collected, everything was collected, but that was fabricated, that was manipulated, and in this case too, the dispensation judge said, I know you have committed this rape and murder, but I am sorry, I can't convict you. Finally, unko saza mil gayi when the people came on the roads and when the case was opened by the High Court. In both the cases, they were convicted and given a life sentence. That is a different issue. But the issue is at the grassroots level, it is very difficult to get justice unless you have some influence, unless you are connected, unless you have a money power or other power, then only you may be in a position to get justice in the court of law. That is why it is not. Of late, you might have heard another case, Nupur Talwar's case. सुना उसके बारे में उर्वशी तलवार
Yes, sir.
Yes, sir.
है और उर्वशी तलवार केस
Her mother killed her.
Her mother.
A doctor family killed Urvashi Talwar.
उसमें भी अभी तक जस्टिस मिला नहीं. उसमें पहले दिल्ली यूपी पुलिस ने, नोएडा पुलिस ने, they swung into action, they couldn't get anything. Then Delhi police came into action, they couldn't get anything. Then CBI came into action, they charge sheeted, and finally with a heavy heart, both were convicted. Talwar, Dr. Talwar, as well as Nupur Talwar. But the High Court acquitted them. Allahabad High Court acquitted them, and the appeal is lying in the Supreme Court after 15 years. Justice, once I say, I don't mean they should have been convicted. By this till date, we could not find that who have actually committed the double murder. And this speaks, there are thousands of the cases. Justice U. Lalit, former Chief Justice of India, Justice D.Y. Chandrachud, former Chief Justice of India. I have worked on this. I have been in one of the biggest central jails in Asia, known as Central Jail Fatehgarh, when I was an AMU scholar. So in way back, I said 40 saal pehle, I have found it myself how many innocent people are in the languishing in the jails. इसमें ये जो मैं चंद्रचूड साहब की बात कर रहा था और जस्टिस यूएल ललित की बात कर रहा था, they are required to say that our jails are overcrowded with under trials. 70 to 80% population of the jails is that of under trials. Under trial means the person against whom the case is pending in the court of law, and the court has not yet arrived to the conclusion whether he has committed crime or whether he has not committed a crime. And both the judges are on record to say, if fair and speedy trial, what they said, if fair and speedy trial is given to these under trials, we are sure, not me, the former Chief Justices, they said, we are sure that majority of them will see the window of freedom. Majority of them will be acquitted and see their freedom. This shows that in our criminal justice system, justice is also blind. There is one of the famous cases, case known as Hussain Ara Khatun case, that is from the state of Bihar. There the poor lady was convicted for committing was charged, not convicted, for committing the offense of theft. Theft at that point of time, even today the position is the same, carried maximum punishment of 3 years if one is found guilty. She was languishing in the jail for about 7 years. For about 7 years, and the court said this speaks about the travesty of justice, that how the justice is denied to the poor people. And mera research kar raha hai, and I am saying it with the authority as a student of law, that I say it in the open court, I have said it in the open court, that if you are in a position to engage a good lawyer, if you are in a position to engage a good lawyer, there is every probability that you will be acquitted even if you have committed a crime. On the other hand, if you are framed, if you are charged for an offense which you have not committed at all, if you are charged for an offense which you have not committed at all, there is every probability, every chance that you will be convicted, provided you are not in a position to engage a good lawyer. I have many personal examples, not the case law, but in addition to the case law, but perhaps the time is not there to explain it to you. Then the second important, इसमें भी बहुत से cases आ गए, जैसे केदारनाथ का है, रंगारंजन का है, छोड़ जो विंडो दुआ का है, freedom of speech. Then the second is that of right of freedom of speech and expression. Usually it comes into the controversy, you might have heard. It is Article 19, 15, 16, and 17. I have not touched it. They also provide the rights to minorities, to various other segments against the discrimination. These are major which I am going to touch. Article 19. Article 19 says freedom of speech and expression. What does it mean? Now, this Article 19 has two parts. One is that it gives you freedom. Fundamental rights have two parts. One part is it gives you certain fundamental rights. The second inbuilt part with the provision itself is that it also provides you the limitations. You have a right of freedom of speech, of expression. You can say whatever you like to say. You can write whatever you like to write. You can talk whatever you like to talk. But at the same time, the second part of the limitation is that it must not be at the cost of others. That is, it must not violate, it must not create any trouble in the society so far as your talking, so far as your expression is concerned. On one hand, you have a liberty to talk, you have a liberty to speak, you have a liberty to express your expressions, but at the same time, you are within limitations that your speech and expression must not violate the same provision. Now here a tussle takes place. Tussle takes place between the individual concerned who speaks, who expresses, who publishes, and that of the state. On certain occasions, you might have seen, of late there was a Dua's case. Even before that, earlier, way back in 1962, there was a Kedarnath's case where something was expressed by the person, by the citizen, and the state came forward, arrested the person under the banner that he violated the law of the land because his speech is going to create enmity, is going to create law and order, or is amounts to sedition. Now, whether it is going to create, whether it amounts to sedition, whether it is going to violate the law and order, create a law and order situation in the society, who will decide it? It is the court which decides. The case lands into the court, constitutional court. Constitutional courts means the High Court and Supreme Court. And their decision that the content of the speaker, the content of the expresser, the content of the writer is placed before the Supreme Court, is placed before the High Court under the jurisdiction, and then the court decides whether it amounts to hate speech, whether it amounts to speech which is going to create violence in the society, in the community, whether this speech or this amounts to what we call sedition. And this is what is. Then the another is right to life and liberty, very important. When everyone has a right to life and liberty, what does it mean? Nobody can be deprived of his life and liberty. That is, even the state has no right to take his life. Murder. It can amount to the offense of culpable homicide, depending upon the situation. Now, this life and liberty can be also taken by the state, but that is as per the procedure laid down in the law. That is, if a person has committed the crime of murder, if he is tried in the court of law and the court is convinced that he is found guilty in a long battle. यहाँ पर एक और चीज जो इमर्ज हो गई मेरे माइंड में, you see, in criminal cases, the first and the foremost comes police. The second agency, which is a part of the police, comes investigating agency, IO we call it. Then comes the prosecutor. Then comes the defense counsel, and on the top is what we call the magistrate. Then after the verdict is given by the court, he may be given the bail or he may be sent to the jail. इस hierarchy में जो agencies of the criminal justice system है, on the top is police, second is judiciary, and the part of the police is IO, and the part of the judiciary, three main pillars in judiciary are that of the prosecution, defense, and the magistrate. And after the verdict is given by the court of law. If found guilty, if not given bail, he will be sent to the jail. If found not guilty, then he will be set free. Now, what is the common man's perception about these segments of criminal justice system? One by one. What is your perception about police? What is your perception about investigating officer? What is your perception about prosecutor? What is your perception about the defense counsel? And then that of the judge, and then that of the jails. Any idea? Your perception about the police? You see, common perception of the police is, yes.
Sir, they are misinterpreting the rules and laws.
You are Dr. Avasti?
Yes, sir.
You see, Dr. Avasti, the common perception of the police, which I am not saying, but which is written in various books, which has been found in various cases, is it is always negative. Now it has two aspects of why we are not in a position to control crime in our society. Police always starts with the negative. That whenever a person is accused, they believe he has committed a crime. Then the second part is police always comes under influence. They are under the command of ABC or under the command of powder, what is called, if money is given, they can change their thought, they can change their thinking. And it has been found many cases do fall at the police level. Number one, police behavior, police attitude in majority of the cases is not positive. And the victim seldom, especially women victims, when a crime is committed against women, the family hesitates to approach the police because of their approach, and then the second, because of the stigma which they feel they will get from the society. They do not approach to the police station for lodging a FIR. Then the second point is the police investigation, which is under the control of police in India, in most of the states. They seldom do not perform the investigation the way they should like. As I told you, in Jessica Lal's case, in Priyadarshini Muthumotor case, even in Oroshi Talwar's case, even in Poolan Devi's case, many cases, the case failed in the court of law because the investigation was not properly done. If the time permits, I will tell you, BNSS, Bharatiya Nagrik Suraksha Sanhita, has brought certain changes which are favorable. But here I must mention you, now it is obligatory. The law of the land is now under new law, BNSS, Bharatiya Nagrik Suraksha Sanhita, 2023. Now it is mandatory for the police. You must note it. Mandatory for the. Am I audible? Am I audible?
Yes, sir. Very much audible. Very much audible.
It is mandatory for the police whenever a crime is committed and reported to the police, and the crime apparently carries a punishment of 7 or more than 7 years. The police has to go to the crime scene along with the videographer and along with the team of forensic scientists. Police cannot collect the evidence unless a complete videography is done, and unless that very videography is done by or in presence of the forensic science experts, which I believe can to a great extent arrest, control so far as manipulation, fabrication of the collection of evidence is concerned. Then to cut it short, when the case is investigated, it is given to the prosecution. Prosecution has to present the case to the court, depending upon the nature of the offense for which a person has been accused. That depends on the hierarchy of the court. जो jurisdiction of the court है, jurisdiction of the powers of the court है, according to the case is handed over to them. Well, here it has been found that most of the cases in the preliminary hearing are not charge sheeted because the judge, after convincing the prosecutor and the defense counsel, they find that the case is not made out. There are some fallacies in the evidence and they dismiss the case. Now, when the case is admitted by the court, it is a matter of fact, every one of us know it. It takes years together. It is a matter of record. Abhi Calcutta High Court ne ek judgment diya, which shocked the entire country. The case was submitted in the Calcutta High Court on the date on which the present Chief Justice of the Calcutta High Court was born. He is at the verge of retirement. His retirement is 62. He is at present at 60 plus. Yani 60 years back, that very case was lodged in the Calcutta civil case in the Calcutta between a bank and some party, and the judgment was given by the same Chief Justice who was born on this in the same month in which that very case was filed in the court. And similarly, in criminal cases, there is a delay. You might have seen a picture, Tariq par Tariq. Tariq par Tariq lagti hai. It is very easy, but BNS and BSA, Bharatiya Suraksha Sanhita, now they have kept some caps. But those caps were already here in earlier law as well. But these caps seldom do not operate at the ground level. It's very difficult for the judges because at present there are more than 5 million cases which are pending in our courts as backlogs, and 1,80,000 cases are more than 18 years. They are pending in the courts for disposal. How the parties witnesses die. One of the parties may die. They may become ill. Finally, the case is filed and no justice is coming up. This is what is happening in our courts. And it has been found, I repeat over here, as I told you, in the courts, again, your money power, again, your influence matters. Apart from corruption, I will not say the judiciary is corrupt, but leaving corruption aside, if you are in a position to engage a good lawyer, there is a chance that you may be in a position to get the justice. But on the other hand, if you are not in a position to get a good lawyer, there is every probability you may be not in a position to get the justice. Moreover, it is rightly said, justice delayed is justice denied. And if justice is delayed by 5 years, 10 years, 15 years, which usually is done, perhaps it loses so far as the charm and concept of justice is concerned. Then finally, so far as system is concerned, criminal justice apparatus is concerned, if a person is found guilty, when we say a person is found guilty, means it has been established in the court of law, he has committed a crime for which he has been charged. Then there is a provision which seldom is not availed of. He can be released on probation, subject to certain conditions. He can be released on parole, subject to certain conditions, depending upon various relative factors. Then finally, he is to be sent to the jail. And here I will just share inputs of a very interesting case through Justice Krishna Iyer, one of the leading jurists of our country. He was Supreme Court Judge, Justice Krishna Iyer and Justice P.N. Bhagwati. They decided two famous cases. The name of the cases are Justice Krishna Iyer and Justice Bhagwati, Sunil Batra versus Delhi Administration. Another is, you might have heard about the name Charles Sobraj versus Union of India. These two famous cases, the judgment was delivered by these two great jurists, great judges. And the Judge Krishna Iyer says in these cases, especially in Charles Sobraj's case, that if you want a diploma in crime, commission of crime, है ना, अगर आप शिकल जानना चाहते हैं कि crime कैसा करना चाहे, you must go to some district jail, ordinary district jail. If you want to have a UG course, go to some great जो बड़ा district हो to that very district jail, central jail. Then if you want to have PG, go to the central jail. But if you want to do PhD in crime, how to learn to commit the crime, go to Tihar jail. And Justice Krishna Iyer is on record कि जेल्स के अंदर इतनी क्रिमिनलिटी चलती है कि मेरे ख्याल में, उसके ख्याल में बाहर सोसाइटी में उतनी नहीं होती. He is on record to say, in by virtue of that very judgment, Charles Sobraj's judgment, some of the prisoners, convicted prisoners who were well off, they had every possible facility within the central jail of Tihar premises. They could get the money as much as they like. They could get even weapons of their choice. They could get drugs of their choice. They could get the liquor of their choice, wine, जो भी उनको चाहे वो मिलता था उनको. And he said even they could get meals from Moti Mahal restaurant. And seventh point, he said they even could get women of their choice and used to enjoy sex in the anteroom of the superintendent of that very jail. ये 1980 में ये judgment deliver हुआ है. And this is the picture which was depicted. Within the four walls, the person becomes hardened criminal. My basic thesis in my PhD was, the longer the term of imprisonment, the less are the chances for rehabilitation. The less are the chances for resocialization. And I am very happy to share with you these my findings. I got my PhD from AMU, the great faculty of law, way back in 1984. And these my findings have been quoted by the Honorable Supreme Court in a number of judgments. In one of the cases, leading case, Rama Murthy versus State of Karnataka, I feel proud. I am proud today, not because I was a vice chancellor for 8 years. I am not proud today at this vague end of my life. I have held key positions in the university system. I am not proud that I am in various central and state committees. I am not proud that I have led various NACP teams as a member, as a coordinator, as a chairperson. I am not proud that I have accumulated by legal or illegal means, that is between me and my God, a good amount of wealth. I am not proud that my children are settled. I am proud that I am being quoted by various courts so far as my findings of my research are concerned.
Sir, is this PhD available on South Ganga?
नहीं, हमारे टाइम में नहीं था ना. It was not in our time. South Ganga.
So can you just share the conclusive part of your thesis today?
I will try. And I will.
You love to read that conclusion.
I still remember. Just last time I had a. This is a different. In fact, I request my perception was to talk to you about the effective teacher, but Madam desired to speak on law and society, which perhaps we shall not be in a position to conclude. This is my pet topic, which I am saying. I always carry. You see, can you just see it?
Yeah, we can see it. Yes, we can see it. It's handwritten, I guess. Well, I have not read it, but it
No,
says
have
the
you ever
conclusion
seen it?
is
You can't read it. It is very minutely written. Have you seen
yeah,
it earlier?
Yes,
देखा
sir.
कहीं?
Yes, sir. We can see it.
नहीं, इससे पहले कहीं देखा ये? What is it?
Seen but not read, sir.
No,
ये
no,
कार्ड
you
पे
can't read
लिखा
it.
हुआ है,
What?
कार्ड पे
What
it's
हाँ,
written on the card.
रिसर्च
Yeah,
कार्ड पे लिखा हुआ है।
research
ये
card. Yeah, this is
मैडम
research.
मैडम कैन बेयर विथ मी। ये हमारे टाइम में हम लाइब्रेरी में बैठते थे, कार्ड पर लिखते थे जो भी हमें मटेरियल मिलता था, जो भी हमें कुछ मिलता था। माय डियर फ्रेंड्स, इट इज ऑफ 1974 जजमेंट,
Reference card, sir. Reference card.
1970 Bhagwan Das versus State of Rajasthan. I was connected. There are hundreds of like cards like this. Hundreds of cards. I can tell you even today what was laid down by the Supreme Court in this case. Very many yeah. And I can also tell you, just at the end, I will tell you what are the. This is my PhD. ये जो है 3 pages में पूरा boiled down किया है मैंने. When I defended in 84 my PhD, while defending, I made these points. I have preserved this right from 84 till date, and whenever I speak on research methodology, I take these tools with me. And I have the communication with the prisoner, which I have laminated, that I also showed to the prisoners. I will come to the findings later on. Well, my dear friends, the crux of my lecture is in our system. It is the law is not accessible to everyone. Justice is not accessible to everyone. It is not the cup of tea everyone. It is very difficult to get justice in the given circumstance because it is very protected, technical, long drawn, expensive in terms of time, in terms of money, and one is held up, one is fed up whenever he is caught up, whether rightly or wrongly in any case, whatever the case may be, and it is very difficult. And in our society at present, जैसे हम कहते हैं जब तक सच्चाई सामने आ जाएगी तब तक पता नहीं कितना जल जाएगा, and you must be very guarded about your reputation because many laws have been enacted where the basic fundamental rule of criminal justice system, the basic fundamental rule of the criminal justice system is everyone is presumed to be innocent unless proved otherwise. Unless proved otherwise, thereby meaning unless the case is proved adverse system of justice, innocent. Now, as I said, you have to be very guarded. You have to be very guarded in the sense here is a shift of this doctrine. In certain cases, a person is presumed to be guilty if the offense charged is offense against the women or children. It has been brought to the surface in many cases our and false cases are being filed. I can't discuss you a very famous case. Very famous case which speaks about the system in which our criminal justice system is concerned. Anukhi Lal, वो उनका ही केस है. Name is Anukhi Lal versus the Rajasthan. Recent case 3 दफा ट्रायल हुआ. बेचारे का एक्यूज का गुनाह क्या था? What a person asked his daughter to get some cigarettes from the shop, a minor girl. The minor girl went to the shop to get the BD, not cigarettes. And the shopkeeper, whether the girl went to him or not, finally the girl was kidnapped by someone. He was raped. After some time, her dead body was recovered. Well, on the theory of lost scene and circumstantial evidence, Anukhi Lal, a poor man who was a shopkeeper, he was a minor at that point of time, but he was convicted. Retrial took place, he was again convicted. Retrial took place, he was again convicted. Well, he was pleading that I have not committed this. He had not seen the girl had not written to his house. Finally, on the DNA test, which was on the basis of the clothes which the girl was wearing and some samples taken from her body, it was found that the DNA test does not match the Bilal. And finally, at the fourth time, after 10 years, he was acquitted. 10 years, poor man. This is how our criminal justice system operates. There are many examples which I can share with you, but perhaps time will not permit. But you are at liberty, time is yours. If you can ask any question. As one gentleman said, what are the findings of my cases? My dear friend, I did 2 years back my PhD.
One final question to you, sir.
Yes, I can tell you what are my findings, just 2 or 3 findings. I said, in my thesis.
Chandravir Singh, please mute your mic. We are not able to listen to sir.
My mic is on mute.
No, Chandravir Singh. I'm asking to Chandravir Singh.
You see, first point was, my point was that you must give an effective legal aid to the prisoners, to the under trials, and to ensure that innocent people are not languishing in our jails. The second most important point, which has been encashed by our Honorable Supreme Court in Krishna Murthy's case, Ramamurthy versus State of Karnataka, is the more the visiting is given, more the visiting hours with the relatives, with the family members to the prisoner, it increases the chances of rehabilitation in the society. I have a background in this because I was myself, one of the close relative, I was a 12th year student. That prompted me to do the research. Next time, if I get a chance, I will tell you about what is the quality research from practical points of view. So I said that more the time of visiting hours is given, it will help. And then the remission must be given. And I also use it to, which the Supreme Court appreciated, I use it to arrange volleyball matches between the university students and the prison inmates in Kashmir, in Srinagar Central Jail. And where our Honorable Vice Chancellor at that point of time was Professor Rais. These I tried to, what I recommended, first I tried to practice it on the ground. And these were 3-4 recommendations which I gave, which have been followed. And you will be glad to know that I had some prisoners in my control group. One of the prisoners was convicted for committing the offense of murder. I can't share you with the facts. I remember the facts. Even after 50 years, I brought him in my this control group, and finally I got him educated. He did a graduation from the central jail through distance mode, and finally I prevailed upon the state government, despite a lot of resistance from the state government, to get him adjusted in the state service, which is against the rules of the service rules. A convict cannot be given a job. A person who has been convicted cannot be given a job. At that point, it was a rule, but he was given with the intervention of the then CM Sheikh Mahmoud Abdullah. And I am proud, as I said, not because of ABCD, but because of these things. He retired as a senior key functionary, superintendent of the central jail, and his family stands rehabilitated. Many cases which I feel proud I have done. As
so one final thing that I want to ask you. One final thing. Since the findings are that the longer the punishment period, the less are the chances of rehabilitation. Well, this finding may go against the delivery of the justice also, because justice is delivered in accordance with the crime. So it can be longer, it can be shorter. So how does this thesis actually helps in the delivery of the justice?
You are, my dear friend, a very right question you have posed, very relevant question. Well, you see, in our penal system, there is a discretion given to the court so far as quantum, except certain offenses, discretion given to the court the imprisonment of either description which may extend up to 10 years, which may extend up to 15 years, or from 2 years to 10 years. Okay. In this case, now a provision has been made in order to meet the issue which you have raised, that is called as doctrine of sentencing under old CRPC 235 section, 235 section, CRPC 1973, and has been retained under this BNSS, Bharatiya Nagrik Suraksha Sanhita. Well, now after there are two stages. One is a person has been found guilty. Then the second stage is after conviction is recorded, that is then the judge has to hear on sentencing, which means what should be the quantum of punishment within the prescribed punishment under the penal statute, under the penal code. That is extenuating and mitigating factors are to be placed before the court. And in the light of, if mitigating factors are more than that of the extenuating factors, then the judge can adjust the sentence. What my recommendation was within the parameters, legal parameters as are invoked or as were invoked at that point of time. I never said if a person is given a death sentence, he should not be delivered the death sentence. That was not my issue.
Yes.
If a person is given a life, he should not be sentenced for the kept for the entire life. My point was that in the life, you see, there must be individualization of the punishment. You are dealing with a human being. Two human beings can be never identical. Your behavior, my behavior vis-a-vis particular action can be totally different. Your reaction, my reaction vis-a-vis particular action can be totally different. You may be calm, I may not be calm. You may be violent, I may not be violent, depending upon the situation. That is why my recommendation was there must be individualization of the punishment. That is, you must give discretion to the jail authorities. If a person who has been convicted and delivered as some quantum of sentence, to what extent he is in a position to readjust, to what extent his recovery back to the society is taking place. That should be taken into consideration, because you will have to admit criminality is a disease. You as an educationist, it is a disease which is to be cured. Nobody, as it was put by Dr. Lambrasso, nobody is born as a criminal. It is the circumstances. In majority of the cases, it is the environment which makes you to lead the life which is not acceptable to the society. And there are many cases where you are being forced. What Professor Sutherland says, you might have read, those who are in sociology, that it is a social engineering, differential association theory, as he has advocated, which makes a person to commit a crime. And unfortunately, our hands, not my hands, the hands of law, are not in a position to catch the big magarmach. We are in a position to catch only those who have been charged and even convicted and have committed some minor offenses, like Malviya, like Chakoshi, like Modi, Pillow Modi. Very difficult for you to lay your hands on such people. And you have also to admit, I raise this once I conduct an induction program, I raise the issue. Ask yourself, close your eyes and ask yourself, have you ever committed a crime? Have you ever committed any violation? If I ask it to myself, well, the answer is yes. Answer is yes. The only difference between me and the one who is in the jail is that he has been caught, I have not been caught. As it is rightly said, is hamam mein sab nange hai. That is why we have to take a view wherein we can get back the one who has become, in majority of the cases, I'm not saying in all cases, victim of the circumstances. That is why
Sorry, sir, I am interrupting you. Sorry, very sorry. I am interrupting you because this is the time for second session.
Okay,
Our
sorry,
next
madam.
session. So thank
Sorry,
you very
sorry,
much,
madam.
sir. Thank you
My
very much, sir.
apologies. My apologies.
Me-
My
no,
apologies.
no.
Thank you,
I
ma'am.
am sorry.
Thank you, sir.
Thank you, sir.
Thank you,
When
sir.
your
Thank
mic
you so
was
much,
open
ma'am.
and
Thank
nobody
you,
was saying
sir.
your
Thank you,
speech,
sir. Thank you, sir.
Thank you very much,
Thank you,
sir.
sir.
Thank you, sir.
Thank you, ma'am.
Thank you, sir.
Thank
Okay.
you, sir. Thank you very much.
All the best. All the best. All the best.
Thank
Thank
you
you.
very
Wish
much.
you all the best.
Thank you, sir.
Dear participants, please join the next meeting immediately because next resource person are with us.
Yes, ma'am. Yes.
Yes, ma'am.
Okay.
Yes, ma'am.